You can't even find it, even if you had a map.
Yeah, I have a hell of a time.
It's a heck of a time up there. They're way up on the top, too.
This is from Mark? Oh, it is. It's from Racing. Yes, it's from the town's attorney.
Yeah.
I was gonna say, this helps us. Okay. I was trying to see, how does this say I can't do what I want to do?
Well, no, if you go read a little further, it's a little different.
Mm-hmm.
Got my phone off, I forgot. Somebody underline this. Okay.
I had to cut it out.
Fairly strong language. It's a Court of Appeals,
How's your child bride doing?
still.
Very well for a child bride.
Oh, good. I met her at the country club.
What's that?
I met her at the country club.
Oh, yeah.
I ate with y'all at the
Oh,
table.
yeah.
Yeah. That's the night you embarrass me.
Our yearly meal.
That's the night you embarrass me when you're home.
Yeah, we always like to go to those things.
Yeah, references
It's been
on
a
that.
centerpiece.
Well, this is the country club where they honored us for being volunteers.
Oh, yeah.
Don't you remember?
Okay, good.
I ate with y'all at the same
yeah,
Yeah,
table.
it was, matter of fact, it's quite simple.
Got a clock.
It works 16 days. Try to stay on. That's the same, but it's 18
Okay, I got it.
I did it in 3 days.
Yeah, I knew you did, so I knew you were good here too.
So,
Was the contract, but the contract choice of venue clause, say it was governed by Tennessee law? That's-
Chair notes that the time is now 7 o'clock. All members of the board are present, therefore the necessary quorum for the conduct of business is present. The first item that must be attended to is the swearing of witnesses. Any person who desires to speak before the board or present any evidence or any type of material pertaining to the matters at hand has to be sworn, and if you so desire to participate, please rise and raise your right hand. You swear that the evidence or other testimony you give before this board shall be the truth, the whole truth, and nothing but the truth, so help you God? All right, thank you. You'll be called upon. First item on the agenda is approval of the minutes of the September 24th meeting, 2014. All members have a copy of the minutes and an opportunity to read them. Is there any discussion of the content of the minutes? Do I have a motion to approve the minutes as written?
I so moved.
Have a second?
Second.
Second?
I have a motion and a second to approve the minutes as written. All those in favor say aye.
Aye.
Those opposed say no. Let the record show that the minutes were approved by unanimous vote. Second item on the agenda is a public hearing on a request for a rear yard setback variance for the property located at 614 Chapel Point Lane, zoned R4, Edward N. and Vicky F. Ashley applicants. Mr. and Mrs. Ashley, are you present today? You're on the end, okay. Mark, the staff have anything?
Yeah, I'll just kind of go through the write-up that I had in the packet there, just to give you an overview. Basically, this item involves a request for a rear yard setback variance of up to 16 feet for a covered porch that has largely already been completed at 614 Chapel Point Lane. This was initially brought to the staff's attention on June 25th as part of a citizen request. And someone had contacted the codes office that somebody was covering their porch without a permit. So we had our code staff to investigate that. And our codes officer, Adam Price, found that in fact they were covering the porch at this residence, and there had not been a building permit applied for. Basically, when he looked at it, and then we kind of looked at the plat for that subdivision, which is off of Grigsby Chapel Road. It's actually the second subdivision as you're going west on Grigsby Chapel Road, on the north side of Grigsby Chapel Road. The unit where the applicant resides is this one that's highlighted here. It's the first unit on the right. So when we looked at that plat, we immediately saw that we could have some problems here, because that basically that unit backs up to the 50-foot peripheral building setback line, which is more clearly shown on that particular image. So we requested, just in fairness to the applicant, for them to have a survey to verify where in fact everything was, because we really didn't know if they had an issue or not. Normally when you submit for a building permit, well, always if you're doing an exterior addition, you have to include a site plan, and that would demonstrate that you would be able to comply with any applicable setback or lot coverage or other zoning related matters. In addition to the building plans that would be submitted to verify that what you're getting ready to build will comply with the building and fire codes. So since that was not done, we didn't have the benefit of a site plan to look at prior to the work being completed. When they did submit the survey, it did show, as we suspected, that pretty much the entire covered porch encroaches into the 50-foot peripheral building setback that's required in that subdivision, and it's required in the R4 zoning district, which is what this is zoned. Basically, as you remember, just to kind of clarify some things, if it's uncovered the way it was prior to the work being done, it's not considered a building. But when you put a roof over it, it becomes a building, and therefore it has to meet the building setbacks. So that's the reason this is in violation of that particular requirement. Basically, we scheduled a meeting, and we went out and met with the Atchleys on July the 18th, and we had a good discussion. Frankly, we were very disappointed that the contractor, who should have known better, did not contact the town prior to the work being done, as it puts the staff and you all in an awkward position to have to address something that could have been avoided had the proper procedures been followed. We basically followed up that on-site meeting with a letter on July 21st and mentioned that in fact it is a violation. We could not issue a building permit for it, obviously, and that they would either need to remove the covered portion or they could apply for a variance. We did indicate that there wouldn't be any grounds for a variance from the staff's perspective, but they certainly have the right to go through that process and make their case. This is actually, as you well know, very similar to a variance request that was unanimously denied a couple of months ago for an accessory building in Stonecrest subdivision, where they actually built most of the building prior to a building permit being obtained. This one is actually a little bit more problematic because it is part of a house. It's part of a principal structure, And unlike an accessory structure, it actually has to meet the building and fire codes that are applicable to that particular addition. Accessory structures do not have to do that. They just have to meet setback requirements. So, that's a big difference, and it makes it more of a potential problem in this case, because since we didn't review any plans prior to the work being completed, we do not know whether in fact the construction does meet the building code requirements. There is a letter in your packet from an architect which gives kind of a broad review of the situation, but there's also a letter in there from our codes inspector who basically could not, assess whether or not it complies with the building code, because again, we didn't look at it prior to the work being done. And then, unfortunately, we received after we did indicate to them that we couldn't approve that, we of course stop work order on the project, because any more work you do obviously is more you potentially will have to remove. But we did get a call a few weeks after that from another resident in the subdivision that some work had been reactivated on that. Our building inspector did tell me that there was some trim work that was, completed even after the stop work order. So that's again a little bit different than what happened in Stone Crest, because they did completely stop the work on the accessory structure after we gave them a stop work order. There's a number of points that the applicant makes in the packet from their view are arguments for granting a variance in this case. And I'll address some of those things briefly, and some points that I think are really important and relevant to this case. The first one and the big one is that all this was done without a permit. So, it's a self-inflicted hardship. It's unfortunate. We certainly didn't, it was an uncomfortable meeting for me to go out to meet with the Ashleys, because we're not looking for problems. We don't want things like this to happen. But had the contractor come to the town prior to the work being initiated, we could have avoided this. So that's a big problem. As far as a reasonable use that's mentioned in the write-up, the property has a reasonable use right now. It's been used as a dwelling unit since 1995. Not allowing a porch to be covered does not affect or change the reasonable use of a piece of property. That's not, a valid point. The lot's configuration, as you saw from the plat, it is constrained by that 50-foot building setback line. But when they bought the property, that should have been known. The units are shown on a plat just like that. So they should have known what the physical limitations were for that lot and what could and could not happen beyond the current footprint of the house. So again, with the lot configuration, this is a self-inflicted hardship. As that court case mentioned at your places, this is a structure that has been built that has created the hardship. It's not something inherent in the property itself. And then finally, the issue of fairness that was pointed out in the application, and the staff's in full agreement with that point. Fairness is very important to the town, and as I mentioned earlier, it would be very inequitable and in contrast to what we did a couple of months ago and what we've done on similar requests like this in the past to grant relief in this case, where you had someone that was unanimously denied for in my opinion, a less of a violation a couple of months ago. And in fact, that building, that accessory structure, has already been removed. The part that violated the setbacks, they applied for a permit to build a compliant accessory structure, and they're largely finished with that. So that's completely taken care of. You know, being citizen friendly is having an equitable enforcement of the ordinance, and it would not be equitable to the people in Stonecrest or anywhere else if we, you know, apply a different standard in one location versus another. So, you know, for all those reasons, unfortunately we could not support the variance request. Again, this has put us in an awkward position. We're not, you know, we don't like to indicate to somebody they may have to remove something, but this was all self-inflicted, unfortunately, and that's the staff's recommendation.
Any member of the board have any questions for Mark? Anybody in the audience have any questions they want to address to Mr. Ashley or to Mark? Okay. I'd like to make one comment before we start, otherwise. One thing that's evidently misunderstood by a lot of people in some of the material that's been provided to us, they're commenting that the patio has been there for 19 years, and they cite that as the reason why it should be allowed to be covered. The zoning ordinance allows patios and other things like that, low to the ground, to be constructed outside of the 50-yard setback requirement, because it's not a structure. It only becomes a structure when you put a roof over it. When you put a roof over it, then it's a structure, just as part of the house. And structures are what makes this in violation. And I think it's unfortunate that the contractor did not advise you to the fact that this was in violation, and get a permit, a building permit. If he'd had, he would have been informed of all the requirements in detail, and he could have passed them on to you. But that was not done. This board cannot in any way change the rules as established by the mayor and aldermen. They are rules that are established in the zoning ordinance. We can only grant a variance for very specific reasons, and one of those is not that it's merely the desire of the owner to do this. There has to be some reason, like you are denied reasonable use of the property. Well, you've had reasonable use of the property for years and years and years. The fact that you want to change the property has nothing to do with it. And with those preliminary remarks, I'd like to ask whoever wants to talk to the board. Let's start with the Ashleys, please.
I would like to speak.
Okay.
Well, certainly
Would you state your name
my
and
name is
address?
Edward Ashley. My wife Vicki. I live at 614 Chapel Point Lane. I might add that I'm carrying this because I lost my hearing about 6 months ago, and so I may not hear you as well as I would like to. So I'm trying the best I can to hear you. Some of you talk fairly softly. My issue is that I don't know if I'm talking loud or soft. So you'll have to bear with me. So you're asking, I can make comments, you're not asking me questions, so I get clarification as to where I start. Okay. You know, we bought this property in 1995. The patio was there. And there's a lot of patios that are there that doesn't show on the plat. A number of people in our community have come down and asked and tried to get permits. And in the past, not somebody sitting in this room, but somebody that was here a couple of years ago said, no patios exist. and we may come up there and make you tear all of them down. So people got to be a little gun shy because of the way they were treated down here trying to get building permits. I only point that out because it's fact. Has nothing to do with what I did. I felt, again, my mistake, that since it was in the confines of the patio, the walls that are there, that I could put a cover over it. Now I realize that I can't. Now when Mark came out, I asked Mark to come out here, and he came with Adam Price. They explained it to me then at that time that I could appeal it, but they're going to turn me down. But I'm doing it anyhow. I'm still coming, and I want to have my voice. I had sent in the things you're seeing on the top there, the pictures are rolling. I also brought extra of these so that y'all could really, from my vanpoint, look at how we feel about it. And I understand you have to have zoning laws, and I understand you have to go with that. But when you start looking at people and citizens of the community, and you got everything that's in black and white and you don't deviate, that's not serving the community very well. I understand you got to have good zoning laws and you want to protect those laws, but every situation is not the same. And I'm having my piece here, but apparently decisions sometimes get made because of exactly what the staff says it ought to be, and we did it this way, so I understand that. I also, in doing this, went and I got legal advice myself. I did not bring an attorney with me tonight, did not intend to bring an attorney with me tonight. But I had the attorney to research it. The first thing that's wrong is the house is setting about a foot over the line from where it should have been. That should have been caught in 1995 by the town of Farragut. At the end of the 7 years, the statute of limitations says that now we have a non-conforming property. And it can be argued that a non-conforming property it has its place where there's possibly be some relief from that standpoint. So if we go forward from here and we have to go to appeals court, we're going to argue that point for sure. This thing is not abusive. I don't know, I'd asked many times if any of you all would want to visit it and look at the situation. Forget what the law is, just look and see what is real, and is this really fair to be able to treat a citizen this way? This is setting on the end of the property, which is very narrow, and just in the narrowness of itself is a reason for being able to qualify for a potential variance if you read the book and what I have in here. In the state of Tennessee planning for variances, they speak that out because of something that has extremely narrowness, that in itself could be a reason for variance. And that one qualifies for that, in my opinion and my attorney's opinion. We have spent a lot of money on it. I was the contractor. I made the mistake. I hired the people to come and do the work. We did stop it, went and got the drawings, and we did site, we did the surveys and all of that and presented it along with that for a building permit, and we got turned down. Well, it sat there, and as it sat there, with the rains that we were having and all, the things were starting to deteriorate. So yeah, I put a gutter on it, and that's what he's talking about. Everything else was there. All the expense had gone to it, and we have completed it. I'm not going to deny that. So I'm at the mercy of this board, and I ask that you reconsider and then really look at the facts and look at yourself and say, I'm here not only to protect the town of Farragut, I'm here to protect the citizens. If I were doing something up there that's going to tear down the looks of my next door neighbor's property or do something that degrades it, that's one thing. But when it adds beauty to the community, something I can be proud of and my neighbors are proud of, I think you people should look at things and say, hey, we can make some changes here. We can make some variances. Even though we forget the other case, you turn somebody down. There's other people in our community who would like to do things, and they should be able to do some things. But whenever the original thing was developed, the developer did it, these patios didn't even show. We understand the 50-foot setback. I look at next door at Farragut Commons, they're not set back 50 feet. So what's the difference? We're R4, they're R4. And they're a lot closer to the line than we are. And there's some covered things on it. I think sometimes you get out in the community, you just walk around and look and see what's there. And say, is that fair that we turn this person down, yet that person has it? I don't see it that way. I live in Farragut, and I love, you know, and I'm proud to live in Farragut. But Farragut has been very, very difficult when it comes to, I don't say difficult, maybe that's the wrong word. Been very strict in what they do, very protective of what's here. But you know, we got to move forward in life. We can't just keep thinking about, well, it's this way and that's the way it's going to be. Farragut's got to grow, and if Farragut's going to grow, you got to attract more people. You'll attract more people if you're fair with the people. You know, the way it was presented by Mark, that I did all this, I'm the villain, you know, maybe I am. My intent is to keep this, and I'll fight it as far as I can fight it. And I'll also fight for the rest of our residents in Chapel Point to be able to do something similar to that so they can enjoy their houses more. You could say, yeah, we've enjoyed it for 19 years. My wife had a stroke. She didn't have a stroke 19 years ago. She can't get out and sit in the intense heat. So therefore, we cannot go out there and enjoy it like we have done. I suffer from skin cancer, and I can't go and enjoy it like I used to. Yeah, I can put on sunscreen. I can put up an umbrella, but I ain't gonna stop the heat. That top right there, what I've done there now, will set the temperature 20 degrees. There's a lot of photographs. I don't know if you've all seen the photographs. You see them flashing up here, but you'd have seen them a lot better if you'd had one of these. And I brought 5 extra if you want to look at them.
Yeah, they got your entire submittal.
In front of them?
Yes. Well, they had it in their packets.
Okay.
I included everything.
I appreciate that. I don't have any other comments.
Mr. Ashley, may I ask you a question, please, sir?
Yes.
Did I hear you correctly? And my hearing isn't that good because I'm probably as old as you are now. Did you
Almost.
say in there that people in your neighborhood had asked for permits to put additions on their houses?
Yes.
And you knew about permits then?
I knew about permits.
Okay, that's it.
I guess I should have done it. I guess I was a little gun shy like everybody else had been. So, you know, it's my fault. I knew about permits. I didn't think, you know, I got the permission of the board of directors of the community. I got their approval to do it, unanimous approval to do it. So that was my mistake, not getting a permit. I had no idea that that unit was setting 1 foot over the line where it should be. I had no idea of that. I didn't know how far it was out 50 feet. I just know that that patio's been there. And putting a cover over that patio, I didn't see that to being such a great thing. It's going to deteriorate or make the community look bad or violate whatever the violations are, so forth. I just think that it's wrong to take that approach when it's something that can work out, that does blend in, doesn't hurt anybody. I just can't see you not towing the line and not making some exceptions. I just don't understand that.
Mr. Ashley, you said that you implied that this error was present some years ago and the city didn't see it. And I would like to point out that,
We didn't know that till we did the survey.
well, no, that your house itself is over 50 feet from the boundary.
I'm sorry, I didn't hear you.
I say your house itself, the outline of your house, is over 50 feet from the boundary line. So there's no violation there. And there's no violation because the patio extended beyond that. Because the patio is not a structure. It's when you put a roof over it, it becomes part of a structure, it becomes a structure. And that is what is against the rule. And
At the time I did it, I didn't realize that, so I'm sorry.
Okay, I agree with you that it's a shame to, you put this work and money and effort in it. And it could be denied, and I think it's a shame if it is denied. But you have to realize that these ordinances are drawn up to affect everybody in town. And there have been a lot of people who wanted to build within these setbacks have been denied permission because they are expected to abide by the rules that are established by the zoning ordinance. And I do not know of a single case in my 15 years as head of this board that we have granted any variance except for a very specific reason. One would be if something to do with the configuration of the land denied you any possible use of that land. And that is not the case because you have lived on that land for many years. And you were not in violation until you started to put a roof on the place. And the fact that you didn't get a permit, I'm surprised because I think I thought everybody was aware that when you build in a community, you generally need a building permit. And I don't know why the contractor didn't inform you of that. And I would trust, Mark, that the city is going to get with this contractor and tell him that if he wants to build in this town, he's gonna have to clean up his act. Because he leaves good citizens in this problem. And the problem with this is not a problem between you and the town, it's a problem between you and the contractor.
I understand.
I would discuss that with him.
I understand.
You understand?
Mhm.
We try to be as compassionate as we can. We like our citizens, and we love our city too.
Mhm.
But part of the reason our city is what it is and why it's the envy of a lot of people is the fact that it does have a good set of rules which are strictly enforced, like sign ordinances and things like that, which make it very nice. And you can drive down Kingston Pike and see the borderline between us and what is controlled by the city of Knoxville. And you can see the difference, why people like Farragut. We like Farragut too, we like our citizens. And I'm not gonna say how we're gonna vote on this, but however it goes, please realize that yours is sort of an unusual case, but the circumstances are brought about by your actions and not ours.
I understand. I mean, I'm not,
Okay.
I'm just trying to lay it out there and look at, and point out that, realize we have the zoning laws, and we have to have those. I'm not denying that. I'm just saying just look at this and see where we have really done something that.
It's not the end of the world for you or for us.
Mhm.
I would suggest there might be other approaches you could take, and it's not our place to solve your problem. I would say if you don't have a porch or a patio with a roof on it, you might consider one of these retractable awnings
Yeah.
as a possible thing to give you some shade.
Mhm.
I realize how that western sun can get.
Yeah. Well, we've looked at that, and even Mark, when he was there, he said it should be, put in a pergola or something like that, but this is what, we could have done that, but that wasn't our choice, and I have to live with what it is, and I have to go by what the law says, and that rests in your hands. I mean, y'all make the decisions there, I don't. I've made my case as best I can. There is a part of that building that's sitting over the line, and it was never discovered. I think y'all might have missed when I said that before, but there's a corner of the building that's right at 1 foot over.
Excuse me.
You can look at the
I look at it as 50.42 from the corner there.
Yeah. That's what I see too, 50.42 feet.
Which that means that it's not over the line.
No, it's not over the, no.
I was told that it was. I'm not the surveyor, and I didn't bring the surveyor with me.
Is this sheet here correct, Mark?
To my knowledge, it's correct.
Yeah, Mark, if you can bring up the boundary survey, we have I'll call it an enlarged excerpt of it.
Yeah, it
but
says
yeah.
50.42 is what I see.
I mean, the looking at Exhibit A on we've got the yellow patio. On the corner of it, this survey seems to indicate that it's 50.42 away from the boundary, which would be more than 50 feet, which means that your entire structure is
As far as
confined and not over a foot.
As far as your building, not your patio, but your building.
Right. We're just talking about the residence.
Yeah, that looks like it is. It's fine.
I had to get the surveyor to He's the one that said it, but I get clarification on it, but I was told it was setting over,
Anybody else have any
which is
questions?
immaterial.
This appears to be, Exhibit A appears to be date of 7/2/14. Is that when you had it surveyed, sir?
I believe so.
Okay, then this survey should be correct then.
It should be.
Should be, yeah.
Mr. Ashley, let me ask you this. Are you currently retired?
I'll be 80 years old next March. I don't think I'll ever retire. If I retire, I'll probably die.
What do you do for work then?
I work as a business consultant. I've manufactured boats all my life.
Manufactured what?
Boats.
Boats?
Did I hear you correctly to indicate that you acted as the general contractor on this project and subbed out all the work to different subcontractors yourself?
Yes.
All right. And as acting as the general contractor, do you know, did you hire any licensed contractors to do the sub work, or did you know different people that you just hired to, you hired to?
I own 2 other units there, and I hire people to do different things that have been trustworthy. So I didn't ask to see their license, I'm sorry.
All right. Do you have any knowledge of the 2012 International Residential Code, which is the code that is in force and effect for constructing things in the town of Farragut at this point in time?
I'd have to be honest with you, I don't.
All right. When you were designing, acting as the contractor for this property, the support for the roof structure, my understanding is that the patio had a concrete slab originally. Is that correct? All right. Did you excavate through the concrete slab to pour additional footing support for any of the supporting structures that hold up the roof?
No.
All right.
I want to put the brackets where it holds the, I'd have to, there's nothing additional concrete that was poured, no.
All right. So if you had supports for the roof, then you just attach those supports with some sort of bolting system to the existing concrete slab. Is that correct?
Correct.
Do you have any personal knowledge of the depth of the concrete patio?
Runs about 6 inches.
All right. And what is your basis for that? Did you build your unit yourself, or did you
No,
drill a hole and test?
there was a pad, and around the pad there was shrubs. And we hired the contractor to come in there about 3 or 4 years ago, dig all that dirt and mulch out. And I know they went down about that far.
All right. And you're talking about the edge lip of the slab that would be apparent from excavating around the outside of the
It's
porch
U-shaped,
slab.
and all of the support beams are on that slab.
Do you know how the rafters were attached to the ledger band that attaches to, my understanding, is a brick veneer that's on the exterior of your home?
There was a 2-by, like about a 2-by-12, which was bolted to the main structure. And then you have big 6-by-6s on either end that's supporting it. You could cut it loose from the house and it would still support itself. Maybe that's put in one beam, maybe.
All right. And did you make those decisions yourself, or
No.
did the people that you hired to do the work make those construction type
Construction.
decisions?
I could not go and say, this is the way you do anything. If I was building a boat, I could, but I'm not building a house.
All right. And my understanding is that until, unfortunately, someone brought this to the town's attention, you'd never talked with any codes officer from the
No.
town to
No.
see if the structure was in compliance with codes or what you had to do or anything like that.
I put a reliability on the person that was building it, the persons that were building it,
Did any of the people that were building the structure ask you, do you have a permit, or do you need us to get a permit?
I think they said they would, I was responsible for getting hurt, and I said, I understand that, so, no.
I don't have any
Any
further
member of the
questions.
board have any more questions for Mr. Ashley? All right, Thank you, Mr. Saxon.
No other questions?
Presentation was very good.
Thank you.
We appreciate it. Does anybody else would like to address the board? Please give your name and relationship to the project.
Good evening, gentlemen. My name is Jeannie Drawn. I live at 650 Chapel Point Lane. I've lived there for a little over 13 years, and I'm a past president of our homeowners association. I've known Ed and Vicki Ashley ever since I moved there in 2001. I know Ed to be a very successful businessman, and he applies his experience and leadership for our homeowners association, and is now the current president of our board, association board. Both Ed and Vicki work tirelessly to make sure that our community preserves its integrity and attractiveness for the residents of Chapel Point and the residents of the town of Farragut. We do require board approval for any improvements or changes that are made to the units, especially in the rear of the units with regard to patios or other structures that might want to be erected. They must submit plans to our homeowners association board, which Mr. and Mrs. Ashley did, and it was unanimously approved by our HOA board. I have taken a look at the structure that is in question. It is very, very well constructed. It is beautiful. It adds to the overall appearance of our complex. I think it adds value to the attractiveness of our complex. I can't speak to the issue of whether or not Mr. Ashley requested a permit, but I do know that I'll speak to what Mr. Shipley said earlier when he mentioned fairness to residents of the town of Farragut. I urge you to be fair to Mr. and Mrs. Ashley and grant them the variance that they are requesting. Thank you.
Thank you very much. Anybody have any questions for this lady? Anybody else want to speak? Somebody else got swore over here. Do you want to speak? Okay, thank you. Does anybody have any questions for the board? Does the board have any other questions or discussion?
I would like Tom to talk about this.
Before he does, Cleve, let me open my mouth
Yeah, go
again.
ahead.
You know I always
No, go
do.
ahead. Well, you always do. Go ahead.
Yes. Gotten old and senile, and I have to do that these days. But anyway, some considerations for us to think about here. And one of them is the permit procedure. Granting a variance or not granting a variance on this can go one of two ways with respects to permits. It can actually negate the permit procedure. And what I mean by that is if someone gets the point that we have assured this variance when a permit was not first gotten, that from now on someone can say, "Whoa, I forgot to get a permit, but excuse me, I'll get one later." This can happen. The other thing it does is it sets a precedent. And you know we've already had two of these cases on here where we have turned down the variance because of them being over the line with respect to the ordinance. If this is accepted, then we haven't been fair to the others that we've considered on these cases. We must reach some sort of an agreement on this, but I think based on those two things, to me, this is going to be a tough one, and I cannot see going against what we've already done.
Anybody have any questions on Mr. Lamarck's remarks? Okay. Mr. Porter, do you have something?
No, I'm sorry, Cleve, go ahead.
No. I was just wondering if Tom could speak to this court case with Clackaroo versus Board of Zoning Appeals for just a minute. I want the public to have a better understanding of what we are restricted by and what latitude we have.
And Mr. Hale, if I can,
Good evening.
if I can get you to introduce yourself.
Sure.
And in specific with regard to Mr. Porter's question, we're interested in the McClurkin versus Board of Zoning Appeals, and specifically, if you want to give the audience a citation to that in the Southwest Record and a page number. I'm interested in the holding of the court, in particular with regard to the what discretion a Board of Zoning Appeals has with regard to granting a variance, especially when something like this, when an improvement has been made without the permit being applied for, and the board is faced with something that on the face doesn't comply with the rules but is already there.
Sure. Thank you. Tom Hale. I'm the town attorney. I live at 12007 Mallard Bay Drive. Let me start out by commenting on the dilemma that you have here and the dilemma that the town always has, and then I'll get directly to this McClurkin case. We are confronted with these kind of situations all the time where we have a regulation that is adopted for the best interest of the citizens by the people that are elected to do those kinds of things, and that for one reason or another there is a situation that develops where there's a violation of those regulations and we discover it. From the lawyer's standpoint for the town, I've always told the staff that our job is to do what the elected officials direct in the way of regulations. If we stop doing what our regulations say that we're to do and we don't enforce them the way they should be enforced, then what happens to us is we have no regulations anymore, because I think what Mr. LaMarche mentioned will happen. It becomes precedent, and everybody then who constructs something nice, admittedly nice, but admittedly in violation of the regulations, would have an argument to come in and ask to be excused from the regulations. Unfortunately, as this case holds, and as the Tennessee Code Annotated states, this body has limited authority. Boards of zoning appeals have authority that is outlined specifically in the laws of the state of Tennessee. The town of Farragut didn't adopt the authority that you have to grant variances. That's stated in those green books called Tennessee Code Annotated that create bodies like this, or give the town the authority to create bodies like this. You then have the authority given to you by the state. And to the extent that you exceed the authority given to you in Tennessee Code Annotated, you've exceeded your authority. So you don't really have the authority to grant variances except as specifically provided for in Tennessee Code Annotated. And Tennessee Code Annotated has a very specific requirements, as you know, as you've been trained in, that and it gets to the issue of where there is some unusual characteristic to the property that creates a situation where the person cannot use it under the existing regulations. And it has to be a characteristic of the property, not a characteristic of the building that is built on the property. Then you don't have the authority to grant a variance. That's what this McClurkin case is about. It involves a building that was built, and that would be at Tennessee Code McClurkin versus Board of Zoning Appeals, 565 Southwestern 2nd, 495. It was decided in 1977. It has been cited in many, many court decisions in this state. And essentially what it holds is that if a person builds a structure that creates the violation that they then seek a variance for, that is not a permissible variance. The variance is to be granted in advance if there are circumstances that warrant an excuse under the ordinance. From what I hear today, there is really not any basis as founded in the court cases or in Tennessee Code Annotated for granting this particular variance. And to do so would be to exceed your authority as provided under the Tennessee Code Annotated. I didn't create that law. You didn't create that law. The staff didn't create that law. The Board of Mayor and Aldermen didn't create any of that law. That law is created by the courts and the legislature of the state of Tennessee. And so our job is not to remake the law created by the people that are elected to adopt it. So I would say to you, unless you have any questions about this particular case or anything else you want to ask me about, I really don't have anything further to say. I don't know, I hope I answered the question that you had. This case is a well-worn case. It's been around for a long time. It's still the law. It's probably going to continue to be the law for the foreseeable future. So other than that, I'll sit down and let you all continue what you're doing.
Any member of the board have any questions for the attorney? Any member of the audience have any questions for the town attorney? Okay. State your question, please.
My name is John Cobb, and I appreciate your analysis, Mr. Hale, but I appreciate the difficulty this board is in. You volunteer for public service, and you get...
Who are you? I didn't hear you say your name or anything.
My name is John Cobb. I'm a resident across the street from Mr. Ashley at 601 Chapel Point Lane. The difficulty you have, and I think Mr. LaMarche pointed this out quite effectively, that if we have codes that we do not enforce, we effectively do not have codes. And yet we're kind of in a situation where you say, I do not have authority to have an exception to the code. And yet, de facto, you are. Because to look at what Ed and Vicki have done, Mr. Ashley and Mrs. Ashley have done, is only brought to your attention when someone brought it to the attention of city staff. And so the question to ask is, where are the other zoning de facto variances that have occurred? Because we've not been in Mrs. Kravitz looking at every piece of building that's been going on. And so, in fact, you're in a very, very difficult situation, because if you don't want to do a variance, which you have a lot of logical arguments to do, you are in fact doing that de facto when nobody comes and brings it to your attention. We're not doing audits of every time we hear a hammer in the city. And so, in fact, you're in a very, very difficult situation. And I think it goes back to what Ed was saying about fairness, and that is we can tell two sides of every story. And we can apply to rigidity. And rigidity can be comforting in a decision. And these are difficult decisions. I think you all have noted that. But let's not fool ourselves to think that the rigidity is as comforting as it is. Because, in fact, we are on both sides of the issue at all the time here. The difference here is this staff was alerted. If staff had not been alerted, we would not be here. We have other properties where staff has not been alerted, and they still exist in our community. And I think that's the situation where you can look at the fairness of the individual, the appropriateness to the community, and to give you some latitude to use the good judgment that the good Lord gave you. Thank you.
Sir, before you go, I understand your fairness, and I'm fully aware and appreciate fairness. But we can't go by fairness here on this board. You heard this from Mr. Hale, our lawyer. If fairness were the way we do things around here, we'd have all kinds of rules and regulations, and we could establish this, that, and the other for anyone. And as far as auditing the entire town by what we have in the staff, somebody wants to do something, we don't go around and spy on everybody in the town. That's not the way to do things here.
But in
People
doing-
should come when they have to build something, know that they have to come to the town, get a permit. Our contractor that has the building for them, is going to build for them, should have a permit and should know that from the town of Farragut. Everyone around this whole area knows that Farragut has very good, solid, strict regulations and ordinances, and we follow those for the good of the people and the good of the community. Fairness is fine, but you can't always go by fairness. You got to go by what you can do, and we have an obligation, and we have only authority to do so much here on this board.
I think you
Thank you.
misunderstand. My point is it's comforting to relax into rigidity as a basis for decision. But in fact, you're using your discretion. You're using your discretion by not sending auditing teams out to every piece of property, which prima facie is ludicrous. But if you follow the argument that Mr. Hale gives you, that's exactly what it leads you to. And in fact, it comes back to this board to use their discretion in the manner that seems most proper for public service. In fact, you're exceeding your authority by not sending spies out, to use the phrase that you do, for the same reason that Mr. Hale outlines. So if you present an argument, you need to pursue it to its logical conclusion. And you see those logical conclusions sometimes reach to the point that they're absurd, and you have to apply some discretion, some intelligence, and fairness. And that's the point I was trying to make.
I believe the town, anytime it becomes aware somebody's building something, they very rapidly check to make sure that a building permit has been issued. And if a building permit has not been issued, then they usually take that up with the owner.
Well, can I
And
follow that up?
we don't sneak around the neighborhoods and audit them and check the backyards and all this. Now, if we should find something that was built that is breaking the ordinance, we would call that person before the city and say, that, look, explain it or tear it down.
And yet, if I listen to Mr. Hale, that is in and of itself exceeding your authority.
No, it's not. No, it's not.
Understand something, it's not the Board of Zoning Appeals that goes after people, okay?
I'm saying the city would do that, not this board.
The only thing the board is doing is going and working on the variance. That's all we do. We're making a decision on a variance. We're not telling you to move your house to the next block or go buy something down the road. All we're doing here is working on the variance, and that's our decision process.
So I understand what you're saying there, but I mean, this is really a difficult situation. I think you feel that, and I don't mean to make it more difficult, but it's not one where it's simply, turn the crank and find the answer. There's discretion here. This is why we have 5 people here with brains and with consideration and with compassion. So I think that's, that's the point I want to make, is that this is not simply
Well, we appreciate that. We've listened to everybody. That's why we listen to all of you.
Appreciate
I didn't,
Sometimes you have to vote not even in agreement with your own personal feelings on things. You vote to back up the ordinance and back up the law.
I would just clarify one thing. I'm not suggesting you don't have the right or discretion to make judgments, but they have to be judgments that you're authorized to make under the statute. The statute has specific standards. The evidence that I have heard tonight don't address the standards that would allow you to exercise that discretion. That's the essence of what my point is. It's not that you couldn't grant a variance if a proper case was put to you. You certainly can do that. But this one is a building that was created that may in fact not even be in compliance with the code because the structure of it hasn't been able to be observed by the codes people. That's a whole other issue that before I got here tonight I hadn't even thought about. And Mr. Alley, your questioning about the code issues brought that to my mind. I'm not sure that even if the building were allowed to stay, it would be in compliance with the code. It sounds like to me it doesn't have proper footers, as required by the code, and no telling what other, I think there are certain specified ways you have to attach the roof to the existing structure that is more than just what an average person might think is appropriate or necessary. I would only say one thing about the issue of fairness. It's kind of like beauty. It's in the eye of the beholder frequently. And I understand that how people can view that issue differently. This body in this town, we don't have the luxury of walking out and not returning here month after month to deal with these issues. And so we have a long-standing need to try to bring some certainty to how our rules are enforced. When I heard that the applicant understood that he needed to get a permit, he understood it was his responsibility, but he didn't get a permit, that was a surprise to me. I was fully thinking that the whole idea of this was just a sheer mistake and not understanding what the rules were. But it sounds to me a little bit like, and that, to me, that raises a real question about fairness if we want to talk about fairness. If you know you have to get a permit but you don't go get one because you don't want to find out something you may not want to know, I don't know that that's quite the kind of thing that we can really countenance, if I understood the testimony correctly.
Yeah, I want to put a human face on this, okay? I've lived in Farragut 43 years. I love Farragut. This is my 14th year on the Board of Zoning Appeals. We're all volunteers. We have families and careers. I'm retired now. I moved to Farragut in 1970 after 30 years with DuPont in medical sales, and I told my wife they would have to dynamite me out of here because I love it. I've owned 4 houses in Farragut, and here's the way it works. When you first get married and move here, I came here with a new wife. I had a small house. Then I bought a big house. Then I got a divorce. Then I had a small house. Then I had a big house. So I've had 4 houses here. And sometimes I go to bed after a meeting and can't go to sleep because the humanistic side of this is wearing. It's very wearing. When I hear your personal story about your health issues, about the son issue, about your health issue, ma'am, I understand all that. We're humans. I go to bed sometimes worrying about it. I tell my wife I'm quitting this year. I've said that every year for 14 years because there's always a case every year that comes before us like your case, Mr. Atchley, and it's very hard to not grant a variance from a humanistic standpoint, and from a logical humanistic standpoint, as this man said, we ought to grant it. But there are issues in the code that people think that because the word variance, the board can grant a variance that we have latitude. We don't have a lot of latitude. We have a very narrow latitude in the annotated code. So I just want you to know how I feel. Thank you.
Anybody else have anything?
Yes, sir.
All ready to vote?
Yes, sir.
Would I have a motion to either approve or deny this request for a variance? Do I have a motion one way or the other?
I would make a motion to deny.
Any
I
other?
would like to add to that, so Keith, we can have something here. And the reason of that is for 2 things. Number 1 is for the procedures which we have in place for permits. We cannot negate that procedure. And number 2 is the ordinances that we have, and we can only go by those. That is our authority here and no more.
I have a motion to deny.
I'll second.
I have a second. Those are in favor of denying this variance signify by saying aye.
Aye.
Those opposed, no. The ayes have it, and the variance is denied. Thank you very much. I have a motion to adjourn.
I so move.
Second,
Second.
those in favor of adjourning, say aye.
Aye.
We are now adjourned.